For delivery of judgment, item 26, WPC 5227/2019. Item 27 for delivery of judgment, WPC 7757/2019.
Yes, Your Lordship. I beg to mention for item number 2, I have affidavit has been sent for testing Lordship. I shall file after reopening Lordship. With consent of the other side, I beg to mention for today. Pass over for today.
You want an adjournment for item number 2?
Yes. Petitioner is present. Charge sheet has been given Lordship. That's why Honorable Court directed us to file affidavit setting the bringing the fact of submitting charge sheet Lordship.
How much time you need?
Immediately after reopening.
File it within the reopening so that we can take it up later.
Lordship.
So that present
14th Lordship, July 14th.
the on the prayer made by Ms. Ravi Boramani. John, I will just take the file and affidavit as directed by order dated 8/6/2026. Next one. The affidavit will be filed on 15/7/2026 based on 17/7/2026.
Deep River.
I beg to mention item 17, Lordship. Yesterday, we have circulated one adjournment slip after taking consent from the other side. So,
17.
no, 17.
What is this IA for?
I have for the condemnation of delay. So, service report is awaited from the respondent number 7. Unfortunately, private respondent. So the conducting counsel is outer station duties father illness, Mr. T. Wangan, Miss T. Walan. So he requested me to adjourn this. 211.
Because we couldn't adjourn it. You see, there's an office note that the respondent of 7 firm has closed for last 4 years, 3 to 4 years. You have to take newspaper alternative service on 7. Unit conflict for the there for the applicant and the respondent numbers. You have for 1 to 6. You have for whom?
ABC.
I'm for forest.
1 to 6. 1 to 6.
Respondent 1 to 6 are present. As per office note dated 24/6/2026. Notice of response number 7 by usual process was received back with process service report stating that the firm has been closed down since last 3 of the 4 years as informed by the owner of the house. Accordingly, the applicant shall take steps within a week for service of notice. On the respondent number 7 by in a substituted manner by publication by publishing the same in one absolute daily, which is having high circulation in Gauhati. The date of appearance in the said advertisement shall be given as 7/8/2026. The publication shall be made within 27/7/2026. Upon newspaper publication of the notice, affidavit of service along with the original newspaper as well as the photocopy of the relevant clipping shall be filed is 2 days prior to the next date of listing. Next part, based on 7/8/2026.
Observe.
Maybe your lordship. Lordship, with the consent of the authorized, I'd like to mention item number 11, lordship. Yesterday we have submitted adjournment slip, lordship. Lordship, I am appearing on behalf of the warden, lordship. We need 3 weeks time to file affidavit in reply, lordship.
Declare made by law counsel for the petition. Is not able to find affidavit in reply to me.
I'm for 3 and 6, sir.
Both sides, yes, sir.
Release item 1 promotion.
Make use of. And the dead body of the petitioner's son was recovered from a pond. However, several injury marks were seen on the dead body. As the petitioner stated all this in the FIR.
You notice here.
And that
Case of the petitioner is that his son, aged about 26 years, had reportedly he was reportedly found dead in a pond in front of a particular school. The deceased had last spoken to the petitioner on 18/4/2026, and the dead body was recovered on 19/4/2026 at about 5 p.m. According to the petitioner, the dead body had visible injury marks. However, no such injuries were reported in the postmortem report. Petitioners project that the petitioner, there are 2 petitioners. The petitioner number 1 had lodged, had gone to the Mayam police station to lodge an FIR in respect of the death of his son. But the Mayam police station had refused to register this FIR. And after hue and cry by the co-villagers, some of the police had thereafter registered the FIR as Mayam police, PS case number 52 of 2025, under section 103 within bracket 1 of the BNS. The respondent number 4 was assigned as the investigating officer of the case. But the petitioner alleges shoddy investigation. The external influence from the IO. Next paragraph. Issue notice returnable on 22/7/2026. Because the extra copies of the resolution was served on the government. Can you go through the government effect on the respond numbers 1, 2, and 3? The petitioner shall take steps for service of notice on respond number 4 by speak out to lady. So given to this, make it 2 working days. The government advocate shall send a download copy of the order to the officer in charge of Mayam police station, just to instruct the IO of Mayam PS case number 22 of 2025 to send updated status report of investigation. List from 22/7/2026.
Item 3.
Maybe taken after some time.
Item 4.
Thank you, Lord. My Lord, the petitioner assailed ex parte order, my Lord. Is 36. Lord. It was dated 14/10/2016. Case of the petitioner is that he never received notice, my Lord. Page 37.
Please come to page 56. Page 56.
Lord. 56. This is, my Lord, after filing review petition. This order sheet.
4/11/24 proceeding action.
Yes, my Lord. After getting knowledge, my Lord, he filed a review petition there. It was numbered at miscase number 1 of 2024. And the review order, my Lord, 11/12/2025. That is page Lord 57. Lordship, that is page 61. Two reports there, my Lord, 61. And second report, my Lord, page 63. Vernacular, my Lord, page 62 and 64.
What for the records then?
That is not clear, my Lord. That is not clear.
And Lordship, the address is same in the notice and the petition filed today. The village address is same. It may even be possible that he has evaded the notice. That basically happens quite a number of times.
Notice was issued.
To be done in the house where she last resided.
Last decided.
That was the order.
Page 64, it is not very clear.
That was the order by the tribunal, but whether it is a fixed date.
লোকজনক উল্লেখিত গাঁৱত বিচাৰি পোৱা নগল ওপৰত স্বাক্ষৰ কৰা লোক দুজনৰ পৰা জনা গ'ল যে এই নামৰ লোক এই গাঁৱত নাই। সেয়েহে উক্ত স্বাক্ষৰকাৰী দুজনৰ সাক্ষাতত জাননীৰ নকল কপি লটকাই জাৰি কৰিল।
Lordship, the inquiry report, which will come in the
I
record.
understand, but you see a single word, adding a single word that the place where it was,
Last resided.
no, place where it was placed, it
Yes,
would have been clear.
yes, that
It
is wrong.
doesn't say, it says that Rattagari Koile, both Koile, that where the
That
word
is
was
wrong.
done, that's not there.
And Lordship, maybe the opinion, if they have come and deposed where they have hanged the
It's
notice.
available only in the record. That evidence was not taken.
Not taken. It's the 2016 Lordship ex parte order, and the review was filed quite, so that means of
Page,
course,
page 40 is the order.
yes, Lordship.
Here, 29(9), notice returned, nobody was examined. We fought for the report. Heard Mr. M. Ali Nanda for the petition, influence for the respondents. I guess repetition in order to the petitioner has said the ex parte opinion dated 14/10/2016, page 36, asked by so and so, in case number so and so, ER of case number so and so, by which the petitioner was declared foreigner for in 1975. When asked for the petitioner's from the process service report, it was not clear as to where the process was served. Notice returnable on so and so. Extra copies in course of the day. Call for the courts. Therefore, bail shall be considered on receipt of the travelers reports. In the meantime, the petitioner, namely so and so, alias so and so, is apprehended, he shall not be deported out of the country without a home report. Petitioner shall cause production of a certified copy of the order before the Superintendent of Police order, Walpara, bring the order to the local service.
My lord, may I pray for interim?
2016 order, Lordship, now.
They give you protection not to be deported.
Yes.
All right.
Item 5.
My lord, impugned opinion dated 2/4/26 at page 105. Contested case, Lord.
Am I saying that process to the petitioner? Page 105, opinion dated 2/4/2026. Passed by so and so and so and so. Notice extra copies in course of the day, after the record. Here, appeal is opposed by the runs and goes for the appeal in border matters. In the projection, 10 days time to take bail or rupees to the government to the satisfaction of Superintendent of Police border,
Nogao.
Nova. List of COVID solicitors.
Who was the last? Surveillance.
6.
Obliged, Lord. May I please, Lordship? Lordship, impugned order is at page 87, annex 21.
27.
Annex 21, age 87. Dated 26/6/2025.
Commissioner
Karim, my lord.
R. Karim, Direct Counsel for the petitioner. Mr. Page 87. Opinion dated 26/6/2025. As per issuance. Notice return in 4 weeks, extra copies, copy to copy. Here for bail is opposed by means confirmed for the FT environment. 10 days time to take bail of this 4,000 to the police border for the this after 4 weeks.
Item 7.
Yeah, because the impugned order at page number 95, my lord, dated 22/01/2026, my lord. Page number 95, the impugned order. Petitioner's mother name is
Mr. T. Sheikh, counsel for the petitioner. The respondents. Page 95. Opinion dated 22/1/2026. 10 days time to take bail of rupees 5,000 to the satisfaction of police border to the
hello,
steps within course of the day.
my lord.
Steps in course of the day.
Petitioner may be protected. Petitioner may be protected.
During bail.
Hello.
Item 8.
May please, Your Lordship. The impugned judgment and order dated 13. May please, Your Lordship. The impugned judgment and order dated 13/2/2026, madam. Page 18.
But Mr.
A Khalek.
Page 18. 15/2/2026. Here there are 4 reference numbers. The copies in course of the day. Notice returnable in 4 weeks. 10 days time to take bail of rupees 5,000 to the satisfaction of Superior Police Border. The Dhubri.
South Salman.
Oh, it can't be South. Ms. Verma. Ms. Verma, please check this page 80.
Lordship,
Please check page 80.
80. Yes, Lordship.
The Superior Police will be South Sarmara Mankachar, I think.
I think 7, no?
South Sarmara Mankachar. Even the police border, South Sarmara Mankachar. The respondable
South
3 is South Sarmara Mankachar, but in page 80, they said the reference was by Dhuri. I think now the district has come.
But Lordship, you go to South Salmara.
Extra copies in course of the day.
All right, madam.
Item 9.
Contested case, my lord. Impugned order is at press pilot. 127,
Order?
127.
As Islam, then transfer for the petitioner and solicitor. Opinion page 127, dated 3/12/2025. Notice notice return of 4 weeks, extra copies in course of the day. After the recording. 10 days time to take bail or rupees 5,000 for the satisfaction of Superintendent of Police, sorry, Deputy Commissioner of Police. No, you have to take.
Metro, my lord.
Pro Metro will be DCP,
DCP Gauhati,
not SP. There's no SP here.
Yes.
No, 2-5.
So difference was forwarded by the SPD, my lord. SPD City Gauhati.
Ten. It's party of both. This is also its party 20.
Superintendent of Police, B, City Gauhati.
Same village, all of Friday.
That references of 2015, you must know when you are dealing with these issues.
Yes.
In 2015, who was the appropriate authority and now who is the appropriate authority?
Item
You must know that.
I'll find that.
Then
4, no? Same village, I think. It's all the same village. Ashdova.
you have to implement it.
Lakshipur. মানে 10
You do it in the vacation.
okay, huh?
Hello.
I'm ready.
You have to file an implementing application unless the authority is there, the SP, there is no SP to receive your bail. DCP, Deputy Commissioner of Police.
Yes.
Implement them. There is some then also for the petitioner, please liberty to file and look at the application. Include Deputy Commissioner of Police, Kanpur Metro Gauhati is. On to number 6. Substitution of the existing respondent number 6. This is don't say there is allowed. This matter as soon as the application is filed. I mentioned before the vacation call.
Individual, he may be put in.
You see, who will give bail? Who will accept bail?
Yes, ma'am.
Who will accept bail? Authority is not there. That's why we are saying, you see, you make a mention before the,
Come in the motion column, my lord. Next one.
you make a mention before the vacation court. Permitting you to do that.
Almost.
Whenever you file it, you bring it to the notice of the court.
Item 10.
Please, Your Lordship. As per the opinion, Lordship, it is 47. Where is that? Page 47. 40? 47. 47. Am I insane by counsel for the petitioner? Insurance of the respondents. Party opinion dated 29/7/2020, page 47.
Party opinion.
Passed by so-and-so influencer. Notice return of allowance for so extra copies in course of the day after the records. Prayer for bail shall be considered on receipt of the tribunal's records. In the meanwhile, if the petitioner, namely so-and-so is apprehended, cannot be deported out of the country without order of the court. The shall cause production of a certified copy of the order for the superintendent of police order This place,
Gwalpara Lordship.
Walpa. The order to the notice of this level not taken. This also is.
14th of August. Offline.
Time being item 3 for motion.
Lordship 3 and 28, both same matter. Lordship 3, time being, Mr. Pang is on legs, Lordship. So it may be taken up with item 28, Lordship. So we wait.
Okay.
No, Ekelo and Hiroto, both are Nigerian nationals, Lordship.
Since the advocate general is here, you have the precedence. Item will be 12.
Item 29 after 12 would be.
Item.
Faith resolution. Well, similar matter, Lordship has already
Have the records.
passed a similar.
So they have gone out of 10. Have to get the records.
Oh, yes, yes. Oh, I'm so sorry.
29.
আমাকে 12 মাত্র 29 My lord, I have made a small note, my lord. এখন দিব নাকি? My lord, basically what we are trying to say, my lord, this Act of 1964, it should impliedly repeal, my lord, with effect from 1/1/2014, when the 2013 Act came into being. Now, your Lordship knows that Calcutta Municipal Corporation's case, Honorable Supreme Court has said, given that the Act of 2013 provides 7 guarantees. In fact, my lord, whether and particular acquisition proceeding is in public interest, that is an aspect also which can be gone into. Now, under the 64 repealed Act, my lord, now they can straight away after passing an order under Section 3, they can take over possession under Section 4. So there is no scope to object, nothing. So therefore, these are repugnant. And in fact, in my note, I have explained that position, my lord. And moreover, my lord, the expression public interest used in 2013 Act and my lord 1964 Act, it can be used overlapping, my lord. Whereas the public purpose for the purpose of 2013 Act is something which is very progressive. As yes, Lordship has passed and similar order, my lord. The Lordship would kindly come to 148. If Lordship kindly comes to page 149.
Another coordinate bench took a different view.
My lord.
Another coordinate bench took a different view.
No,
No.
not on this case, my lord. Here we are challenging the very, my lord, virus of the Act itself, because that Act is no longer there. My lord, how can an amendment made to the Central Act revive an Act which stood repeal?
No, but I am.
If your lordship, same locality, same my lord Moza, same area, my lord. This is the order which your lordship passed. Now state has filed their appeal in the affidavit in their case recently.
In that case. And it is fixed on 23/7.
And 23/7 the cases are fixed.
Yes.
If your lordship would kindly come to
The
140.
submission that it is a covered case and all the facts are same, that is not correct. Because a major change has taken place. Lordship will kindly come to page
No,
140.
let me complete, my lord. My lord, what had happened in this case, my lord? Finally come to page number 142, my lord. No, way to order before.
Your Honor.
I'm sorry, Milord. Please come to Milord, page 1086. heavy system to ekdam patla de amara line dal dita ki buঝো Please see, Milord. This is the first step they have taken in exercise of the power conferred on me under section 3(1) of the Assam Land Acquisition and Acquisition Act, under notification dated so and so, I, Sri so and so, District Commissioner and Collector, do hereby requisition under section 3(1) of the Assam Land Acquisition and Requisition Act 64, the land described in the schedule below with effect from the date of this order. So that means, Milord, with effect, the moment the notification is issued, the land vests in the government.
But there are procedures for filing objection and all.
No, Milord. No. That is not the no. With respect, Milord. Kindly come to next notification. No. Where is the question of this is an act which does not exist in the eye of law. That is our case.
Impliedly repeal.
Yes.
But not repeal.
Implied repeal. That position has been previously accepted by this court. That's why in the earlier case that order was passed. Then Milord will kindly come to 104. There's no question of filing objection. Please come to 104. Whereas the land described below has been requisitioned under section 3(1) of the Act, you being the owner, tenant, etc., are directed to surrender or deliver possession of the requisitioned land to the collector. What is this, Milord? Whether they can do the same thing under 2013 Act, because there has to be an award, before that they have to undergo so many processes. That is why this Act is repugnant. Now, Milord will kindly come to 2013 Act. Please have 2013 Act. Why it is repugnant, that I am trying to show, Milord. Today, Milord, the Assam Tribune a news item has been published where, Milord, a particular business group is trying to develop this land. Section 4, Milord. Now, in a case under 2013 Act, how the things proceed? That is what I am trying to show. Section 4, I am not reading it, Milord. Preparation of social impact assessment study. Step number 1. Then, Milord, will kindly come to section 5.
So by this Act, land acquisition of 1894 was repealed by this 2013 Act.
So, Milord, what I am saying is, under the constitutional scheme, once a central law is there, a state law stands repealed. There cannot be a state law because the provisions of the state law are repugnant. Am I clear to your lordship? That is what I am trying to show by referring to this section.
It's in the concurrent list.
Yes. Now, section 4 says, before any acquisition is made, there will be a preparation of a social impact assessment study. Now, I have shown this scheme of 1964 State Act, where the moment they issue a notification, the land vests in the government, and then, Milord, under section 4, they will direct people to get lost. These are the two procedures envisaged in 1964 Act, State Act. That's why I'm saying this is repugnant to the Central Act. Therefore, it is impliedly repealed. Now, section 5 envisages public hearing for social impact assessment. Then, my lord, kindly come to section 6, publication of social impact assessment study. Then section 7, appraisal of social impact assessment report by an expert group. Then, my lord, will kindly see section 8, examination of proposal for land acquisition and social impact assessment report by the appropriate government. Then, my lord, chapter 3 provides special provisions to safeguard of food security, etc., etc. So, my lord, therefore, the moment a state law, which is on the same subject, is repugnant, then, my lord, it has to make room for this Central Act. Now, we therefore, our submission is, with effect from 1st of January 2014, the day the Central Act was gazetted, my lord, the State Act is impliedly repeats. Now, my lord, will kindly have my that point written note which I have given, my lord. Please come to that point number 2. Central Act 30 of 2013 is a beneficial piece of legislation aimed at ensuring higher compensation. Central Act envisages right to notice, right to be heard, right to a reasoned decision, duty to acquire only for public purpose, right of restitution or fair compensation, amongst others. Whereas Section 3.1 and 3.4 of the Assam Act empowers the state to requisition land, take possession of the without undergoing any of the procedural safeguards provided in the Central Act of 2013. Therefore, Assam Act is repugnant to the provisions of the Central Act. Thus, the provisions of the Act are also violative of 300A. The provisions of the State Act is violative of Article 14 of India inasmuch as public purpose defined in Assam Act, Central Act are all pervasive and can be resorted to at the volition of the state, thus creating a class within a case. Lordship knows in Nagpur Municipal Authorities case, my Lord, Supreme Court says you cannot have two acts because if you apply 64 Act, then your rewards are less. You need to pay less. When the moment Central Act comes, you have to apply all this. So on the same field, there cannot be two law.
Unless President gives the assent to the extent.
Exactly. I'm obliged to your lordship. Now, what had happened here? There was a presidential assent in respect of the State Act, but that was in 60s. So now, my lord, now they have amended the Assam Act. Even that, kindly see what they have done, my lord. Please come to that amendment that will make the position clear. Please come to page number 142, my lord. This is the Assam amendment. Please come to page 145. No. Lord, I was referring to the point of Milord repugnancy. Now, if your lordship would kindly have the judgment, Milord, 1973 1 SCC 500. দিয়েছেন পাইছে নাকি? Hello, did you go again? লোৱা নাই।
73 1 SCC.
73 1 SCC 500. It's a constitution bench judgment, Milord, Nagpur Improvement Trust versus Vital Rao, a very famous case. It says if there are two acts are available, now here two acts are available, 64 which is repugnant. Well, in the other case, the order which I have annexed pertaining to the same process that was earlier in point of time, now they want to acquire the whole area, Milord. Entire stretch of land just opposite the new airport, Milord, they want to acquire everything. People are, Milord, these are all homestead land, Milord. People have taken loan, people have constructed their house, now this is sought to be acquired. It's a welfare state. That's why under the new act, Milord, whether it is in public interest, that is also an aspect which can be gone into. Earlier it was not available under the 1894 act.
The last line in section 3 of 1964 Act.
Milord, yes.
There it is said after requisition, the state.
Under section 6, they can acquire.
In requisition, I'm saying the 3, last line.
Yes, Milord.
The state government will make such further order as appears to him or to him to be necessary
Yes.
or expedient in connection with the requisition.
Yes.
Last time.
114. In fact, Lord, yes, Lordship was referring to section 3.
Last line.
Yes. State government or the person, so as the case may be, by order in writing, requisition any land and make such further order appear to him to be necessary or expedient in connection with the requisitioning, provided no loose for religious shall be so and so. Yes. So this power has been invoked and they have requisition. Now under section 4, we have been given notice to vacate now. There is no proceeding, there is no award, no nothing. Because this is the special power which is given in this act. And therefore, this act is repugnant to the act of 2013. I think it's an open and shut case, Milord. There is no scope for any argument also on this. To that extent, this is repugnant. That's why it is said, Milord, if a state makes a new law and reserves it for assent of the president, then it will be a different aspect. Because end of the day, yes, Milord. Please come to paragraph 29 and 30. Can classification be made on the basis of public purpose for the purpose of compensation for which land is acquired? In other words, can legislature lay down different principles of compensation for the lands acquired for a hospital or a school or a government-owned building? Can legislature say that for hospital, land will be acquired at 50% of the market rate, for a school at 60% of value of the land, at 70% of the market value? all these objects are public purposes, and as far as owner is concerned, it does not matter to him whether it is one public purpose or the other. Article 14 confers an individual right, and in order to justify a classification, there should be something which justifies a different treatment to the individual right. It seems to us that ordinarily a classification based on the public purpose is not permissible under Article 14 of the for the purpose of determination of compensation. The position is different when owner of the land himself is the recipient of the benefit from an improvement scheme, and benefit to him is taken into consideration in fixing compensations. Can classification be made on the basis of the authority acquiring land? In other words, can different principles of compensation be laid if land is acquired for any improvement trust or municipal corporation or government? It seems to us that the answer is in negative, because as far as owner is concerned, it does not matter to him whether the land is acquired by one authority or other. Now, para 30 is important, my lord. It is equally immaterial whether it is one acquisition act or another acquisition act under which the land is acquired. If the existence of two acts would enable to give to one owner different treatment from another equally situated owner, which is discriminated against, can claim protection under Article 14. I am on this, my lord. Now kindly see, the moment Section 3 notice is issued, the land rests in the government. The moment they invoke the power under Section 4, we are bound to deliver. There is no award, no acquisition, nothing has taken place. Whereas, my lord, under the scheme of 2013 Act, there are so many safeguards, including the aspect whether a particular acquisition is in public interest, even that can be gone into. Now, my lord, recently there is a judgment of the Supreme Court. There's Kolkata Municipal Corporation versus Bimal Kumar Shah. Please have this, my lord. 2024, 10 SCC 533. 2024, 10 SCC 533. Madam, paragraph 29 to 32, Miller. If a lordship would kindly have para 29 at page number 550, Miller. Yes. The constitutional discourse on compulsory acquisition has hitherto rooted itself within the power of eminent domain. Even within that articulation, the twin conditions of the acquisition being for the purpose of public purpose and subjecting the divestiture to the payment of compensation in lieu of acquisition were mandated. Although not explicitly contained in Article 300A, these twin requirements have been read in and inferred as a necessary condition for compulsory deprivation to afford protection to individuals who are being divested of the property. A post-colonial reading of the Constitution cannot limit itself to these components alone. The binary reading of the constitutional right to property must give way to more meaningful renditions, where the larger right to property is seen as comprising intersecting sub-rights, each with distinct character but interconnected to constitute the whole. These sub-rights weave themselves into each other, and as a consequence, the state action or the legislation that results in deprivation of private property must be measured against the constitutional net as a whole, and not just one or many of its strands. What then are these sub-rights or strands of this Swadeshi constitutional fabric constituting the right to property. 7 such sub-rights can be identified, albeit non-exhaustive. These are duty of the state to inform the person that it intends to acquire his property. 64 Act, no scope. Duty of the state to hear objection to the acquisition, right to be heard. Duty of the state to inform the person if his decision to acquire, the right to a reasoned decision. The duty of the state to demonstrate that acquisition is for public purpose, duty to acquire only for public purpose, duty of the state to restitute and rehabilitate, right of restitution or fair compensation, duty of the state to conduct the process of acquisition efficiently within the prescribed timelines of the proceeding, right to an efficient and expeditious process, the final conclusion to the proceeding leading to vesting the right of conclusion. These 7 rights are foundational component of a law that is in tune with Article 300 capital A. An absence of one of these or some of them would render the law susceptible to challenge. Judgment of this court in so-and-so declares that the law envisaged under 300A must be in light with the overarching principles of rule of law, must be fair and reasonable. It is, of course, precedentially sound to describe some of these sub-rights as procedural, a nomenclature that often tends to undermine the inherent worth of these safeguards. These 7 sub-rights may be procedures, but they do constitute real content of the right to property under 300A. Non-compliance of these will amount to violation of the right, being without any authority of law. So if we, after reading this passage, my lord, where is the scope to give judicial imprimatur to the requisition orders at which we have annexed, that is form B and C? A stroke of a pen, you requisition, next day you say hand over possession. Nothing has happened thereafter.
But section 3 of 64 Act talks of urgent public purpose.
Well, what is that urgency?
See this section.
No, well, I'll explain. My lord, this section 3 was basically invoked, my lord, in times of flood, in case of external aggression. My lord, what happens? Sometimes land is required urgently. Now, my lord, to make aerocity, what is the urgency? To make aerocity, what is that urgency that you are invoking once 1964?
That is a different
No, no, that is the reason. That is why they are acquiring this land. Now today, 81 families are before the lordships. Their homestead land where they reside is sought to be acquired. Why? Because they want to develop an aerocity. This is no public purpose. Aerocity is not a public purpose, I argue. Let us be very clear about for certain things, my lord. There is a constitution.
So that is on facts, but
Yes.
64 and 30.
Now, my lord, it's a very simple case. These 7 safeguards are not available under 64 Act. Therefore, instant declaration should go that this act is null and void. Now, what they have done, my lord? Now, recently in 2025, they have made an Assam amendment of the Central Act. Does an Assam amendment of the Central Act revive an already repealed act? So first they have to repeal the Central State Act, then they can invoke. So, my lord, these matters are fixed on 23rd, the main matter for final hearing. Let, my lord, the similar order be passed and let the matter be fixed on 23rd. And I reserve my right of reply, my lord. Oh, so sorry.
Declare void and inoperative.
If I have gone through the repetition, if Lordship is pleased to come to page 4, in the matter of, in the clause title, there are 81 number of petitioners. And their submission was that all are equally and identically situated. But if you look at the impugned notice, 13 names are not appearing there. That means they are not patta holders. We can acquire a land when there is a patta. So out of 81, 13 are encroachers or illegally residing there. So they have to segregate the repetition first. They have to come to this honorable court with clean hands, not to mislead the honorable court. The notice contain number page 86, Lordship will see. The notice which was issued on 10th of June, if I am not wrong. It's a notice given to about 500 and more than 575, 1000 plus. But we could not find the names of 13 out of the 81 petitioners before this honorable court. The notice was issued to 1010, that means 1010 number of patta holders in village Goral and notice was issued under section 3(1) of the Assam Land Requisition and Acquisition Act 1964. So whatever order this honorable court either grants a order or something else also, whatever, it should be applicable only to those pattadars. But I have serious objection regarding passing of any interim order because their whole case is based on the earlier order which Lordship was pleased to pass at page 147. It was passed on 3/11/2025. A vital aspect was not argued before this honorable court on that paper. So may I read from paragraph 2 because this is the order which they are seeking now. They are seeking it's a covered case and let the matter come up on 23rd of July. That is their prayer, basically. If Lordship comes from paragraph 2 to paragraph 11, there is no mention on behalf of the state to make any submission regarding the presidential action which was obtained on 17th of May 2025, which is a major change at that point of time, but it was neither argued nor recorded by this honorable court. Why that is very relevant? Because this order was passed on the contention and also the same argument is being made that there two acts are in place. One is repugnant 1964 is either repealed or repugnant to the 2014 or 2013 Act. So that is their argument, but that very critical point is neither argued or nor recorded by this honorable court while passing the impugn order. Now I'd like to place the 2013 Act, Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act of 2013.
So you mean to say presidential assent was received to the extent of repugnancy?
Exactly. So their whole case crumbles. I'll satisfy this honorable court. Lordship will kindly come to that Act of 2013, Section 105. May I read it, Lordship? Provisions of this Act not to apply in certain cases or to apply with certain modifications. Subject to subsection 3, the provisions of this Act shall not apply to the enactments relating to land acquisition specified in 4th schedule. Lordship will kindly come to now 4th schedule. About 10 acts are mentioned here. 4th schedule under section 105, 13 acts are mentioned. We don't find the name of 1964 Act of Assam, Acquisition and Requisition Act here. Have Lordship got it? So section 5 says certain acts are not applicable to the Act of 2013 and the name of the acts are mentioned in Schedule 4. So Ancient Monument and Archaeological Sites and Remains Act 1958, Atomic Energy, Damodar Valley, Indian Tramway, Land Acquisition Mines Act, Metro Railways Construction Act, National Highways Act, Petroleum and Mineral Pipelines Acquisition Act, Requisition and Acquisition of Immovable Properties Act, Resettlement of Displaced Person, etc., Coal Bearing Areas Acquisition and Development, Electricity Act and Railway Act. In Assam, we have amended that. That is a part of the writ petition now. Page 142 now. Here, Lordship will come to page 145. So every central act, there is a provision of state amendments. Like in CRPC earlier also, we have state amendments. That is permissible. 145, insertion of new section 105A. That is to the central act. May I read it now? 105A, subject to subsection 2, the provisions of this act shall not apply to acquisition of land under the enactment specified in 5th schedule. Earlier it was 4th schedule, now 5th schedule. So the 5th schedule act will also not be applicable to this act of 2013. Now page 146. 5th schedule under section 105A, list of Assam enactment regulating land acquisition in the state of Assam. The name of the act is Assam Land Acquisition, Requisition and Acquisition Act 1964. And Lordship will now come to page 142. Assam Act of 7 of 2025, second paragraph, received the assent of the Honorable President of India on 8 May 2025. Now coming to section 54 of the Constitution of India. Section Article 254, sub-article 2. Article 254 says, inconsistency between laws made by Parliament, Lordship. I am referring to 105A. Have Lordship got it? 105A, Lordship will find at page 145. Insertion of a new section 105A. So after 105, 1A has been inserted, which says, subject to subsection 2, the provisions of this act shall not apply. That means 2013 Act shall not apply to acquisition of land under the enactment specified in 5th schedule. So now we have to see what is 5th schedule. I can read the subsection 2 also of 105A, subsection 2. The state government by notification within 1 year from the date of commencement of this act directed any of the provisions of this act relating to determination of compensation in accordance with the fifth schedule, etc. This is not very relevant. Lordship will kindly come to fifth schedule. The act is Assam Land Acquisition and Requisition Act 1964. So 1964 Act is now applicable in case of land acquisition in the state of Assam. But however, we have issued a notification in 2005-15 saying that in all procedures of land acquisition, 1964 Act will be applicable. So far as compensation part is concerned, the 13th Act will be applicable. So when we acquire some land, we acquire as per the procedure laid down in the 1964 Act, and the compensation which has to be quantified, it is under the new Act of 2013. So people are not affected that way. They will get the
Compensation provided in 64 Act also.
yeah, but we are giving. We are not that stringent. We are a little bit liberal, the state government. So assessment,
25 notification is in respect of the state of Assam only.
exactly, Lord. Assam amendment.
Of Assam.
And Assam amendment, because we have to deal with the central act, and therefore the presidential assent has to be taken under the sex provisions of Article 254. So may I just read 2-3 lines from the Article 254? Article 254. Inconsistency between laws made by Parliament and laws made by the legislature. If any provisions of a law made by the legislature of a state is repugnant to any provisions of law made by the Parliament, which the Parliament is competent to enact, or to any provisions of an existing law with respect to one of the matters enumerated in the concurrent list, then, subject to the provisions of Clause 2, the law made by Parliament were passed before or after the law made by the legislature of such state, or as the case may be, the existing law shall prevail, and the law made by the legislature and of the state shall, to the extent of repugnancy, be void. Coming to now 2. Where a law made by the legislature of a state with respect to one of the matters enumerated in the concurrent list contains any provisions repugnant to the provision of an earlier law made by the Parliament or an existing law with respect to that matter, then the law so made by the legislature of such state shall, if it has been reserved for the consideration of the precedent and has received the assent, prevail in that state. So we have received the assent, and therefore it will prevail in the state of Assam. I can argue on this point for 1 hour, Lordship, but the law is very clear without any ambiguity. That is why we took the presidential assent. So in that view of the matter, if Lordship is pleased to examine the order passed by this Honorable Court on 3rd November 2025, on the basis of which the interim order was passed to protect their interest, this vital point was neither argued nor recorded. So whatever we are doing, it is as per the mandate of the state amendment of the 2013 Act, 2019-64 Act, and everything is within the permissible limit. We have not transgressed the mandate of the Constitution or the 2 statutes. That notification I would like to place of 8 May 2015. Lordship may have a look of this notification, which is a part of our affidavit, which is not before this Honorable Court today. I am just placing that affidavit of 2015 Act regarding the quantum of the compensation, additional compensation, etc. It has to be done in terms of the 2013 Act. So my submission would be, Lordship, had this very vital fact been placed before this honorable court when the matter was heard at the time of passing of the interim order, in my humble view, Lordship, or in my humble submission, Lordship would not have passed this interim order, because this vital aspect should have been placed and argued by either side. So this presidential assent has granted the state the authority to invoke the 1964 Act. It was part of the record. It was neither placed and showed to the honorable court, because at the interim stage, Lordship will not minutely examine each of the place. Now, one thing, out of 81 petitioners, luckily we verified that out of that 13 are not patta holders and they did not receive notice. So there is no cause of action arising against them. The Great Tribe then misled this honorable court. Very clearly said all are affected, the submission from the other side. So these are misleading statements.
Happen because under the Acquisition Act also, Section 5 says give the liberty to the people who are actually affected to come before the office.
But when they
When state does not know that in a land acquisition act, person interested is what matters, not the patta holder. In land acquisition act, my lord, yes.
I am used to it, Lordship, no issues. So the thing is that, Lordship, when a notice has been issued, which has resulted or triggered the cause of action, that is not there. For illegal encroachers also, a notice has to go under the Land Revenue Regulation of 1986. That notice under Regulation 18. That will go in case there are illegal encroachers. But when it is a case of patta holders, the case is different. Lordship knows the difference. So at this stage, Lordship, we will file a detailed affidavit and their statement here. Lordship will kindly see paragraph 2, how it is misleading. Not only submission they are misleading, in pleadings also they have misled this honorable court. Paragraph 2, page 28. That all petitioners are absolute owners, plot of land situated in district Kamrup, Moja, Pargana, Ramchari, and village Mirzapur and Ajara. The petitioners have filed an instant petition before the on being agreed by the impugned action of the respondent by initiation of acquisition proceedings. We don't acquire land from encroachers. We evict them from that land. Requisition and acquisition is relevant and is applicable only in case of land patta holders. If they are encroachers, then we evict them. The notice will go for eviction, not for acquisition, neither for requisition. As such, the petitioners have a common cause of action. Then why their names are not figured in that notice at page 42? Then paragraph 3. The petitioners hearing are absolute owners of the land situated in so-and-so, and some of them have dwelling houses. This is very important. 80 to 90% land are all vacant. There is no homestead. It is further said that some of them have gathered property bounded by boundary walls. So boundary wall is there, no house. So homestead or dwelling houses is different from boundary walls. It is further stated that some of the petitioners do not have any other landed property. Most of them have landed property. Most of them. We know who are the identities of these people. Everybody is waiting that the maximum amount they can get. This is the game plan. The petition, but we are fighting it legally, Lordship. We will not go to those extraneous considerations. The petitioners are annexing land ownership documents of some of the
But that is not,
That is not our,
it's not wrong. If people have a
no,
claim for a.
now they are making, it is as if constructing a aero city is a trivial issue. It is not in public interest. When you look at the state of Assam and the state of Gauhati, 10 years, 20 years down the line, we have to go upgrade our state. We have to upgrade our city. For that, some hard section we have to take at some point of time. We have to do it if we want to see Assam growing and competing with the rest of the world. But it is not a case that we'll throw them out. They will get adequate compensation also. They are having land there. Alternate land they can be able to procure. Let the commission be engaged there, Lordship, from the advocates. We are ready for that also. What they are projecting by verbal arguments in the court is not actually visible in the site. And government's eyes are also open. So the petition will be to honorable to submit land ownership documents of each other as and when directed. So they are waiting for this honorable court to produce their documents. So my humble submission is that, Lordship, all 81s are not identically situated. The cause of action has not arisen in case of 13 writ petitioners. They should be struck off immediately. I can give the numbers also. 39, 38, 47, 56, 57, 61, 71, 73,
That
7.
happen only after you file an affidavit.
Absolutely.
The other side has to have a protest.
Whether that construction of aeropolis, aeropolis comes within the purpose under section 3 of the.
Yes, Lord. Yes.
So section C, section 3, it is for very urgent purpose,
Exactly.
which is better for the
Yes.
society.
Yes.
That is a subjective opinion, but I can place why Aerocity is there in Delhi. Why there are all the industrial areas surrounding Delhi, Mahipalpur.
That
Why?
is required for upliftment
Because
of-
what is happening, Lordship? The whole area, Gauhati is going to have a satellite city, and all the surrounding areas are full of industries now. This area will be full of industries. If you cross airport and on both sides, Assam government about 3 years ago had announced that 4 or 5 kilometers from on both sides of the highways, these are all industrial lands now. No more agricultural land. The problem with Assam was that, Lordship, it may appear like a political statement. Assam was not having industry in our state.
Just
and
an
the-
employment problem.
To tackle that, neither any of the minister or any of the other persons is going to procure land for private interest. No. Whatever we are going to do, it is for the interest of the state. So what is the reason? And nobody objected, Lordship. The persons who are having land on both sides of the highways from Mirja up to Nolbari or maybe up to Bojali, Patsala area, both sides. This was announced, I think, around 2022 or 21. All the agricultural lands, they are converted by that notification as a industrial and plot of land. And as a result, lot of industries are growing up there. And the bigger plan is, Lordship, it will be the ideal place for having the Indian commerce with all the neighboring countries. It has a vision for 20 years down the line. I'll not use the word Viksit Bharat here, but that is the ultimate aim of the government of India as well as government of Assam. We are forcing something for 2047, and there is nothing wrong. And that public interest is not having any color of any political party. So this is my submission at this stage.
Yes. My lord,
So that interim order is not applicable in the case that there is a huge difference. The legal position has changed. It was not placed before this honorable court. The honorable court did not consider that vital aspect because it was not pointed out. I could not find a single whisper in that interim order. So as because the presidential assent is there, we are well within our limits to do whatever act we have undertaken. Deeply obliged.
my lord, this argument that regarding this amendment, we have not made any statement. That is absolutely wrong. I think my learned friend is not properly briefed. My lord, please come to para 15, page 37. Why this presidential action is of no value? And the same statement appears in the earlier writ petition also. My lord, my learned friend was not present when the case was argued last time. How does he know what I argued? There is a limit to everything, my lord. Para 15. The decade later, state of Assam introduced right to fair compensation and transparency in land acquisition, etc. Act, hereinafter referred to as the amending act. The same received the assent of the president on 8/5/25. The amending act introduced several amendments, including following amendments which are relevant for so and so. I may skip this amended portion. Please come to para 16 at 39. The said amendment was published in the official gazette on 17/5/25. By introducing the aforesaid amendment, state of Assam has attempted to do away with the procedural mandate of Act of 2013, thereby depriving the public, including the petitioner, of the beneficial scheme and safeguards enshrined therein. Pertinently, the amending Act of 24 does not speak of any retrospective operation. The petitioner begs to state and submit that Act of 64 and amending Act are ultra-virus to the Constitution. The virus of the enactment is challenged on the following ground. So, my lord, same averments appear in the earlier petition. Earlier petition, my lord, 18 to 18, 19 and 20 in the earlier petition. Now it is 15, 16 and 17. In the earlier petition, it is 18, 19 and 20. My lord, we are testing a legality of a statute. My lord, I think I don't have to argue much on the point that 64 Act or 2013 Act is repugnant. So it's to repeal because there are repugnancy. Now, my lord, can by a state amendment of the 2013 Act, a repeal act be revived? At least, my lord, to my knowledge, I have also done some cases on constitutional law. I have not come across any such, my lord, proposition that state, by exercising amending powers in a central act, can revive a repeal state law. Am I clear, my lord? Now, number two, I don't think anything else is required. One statement has been made by the council for the other side that for acquisition we are applying 64 Act, for compensation we are applying 13 Act. That itself is enough to allow this information today, if I have understood the legal position correctly. Because law officer of the state is making a submission that acquisition is under 64 Act and compensation is under 13 Act. Now please come to that Nagpur case once, my lord. The implications should be taken note of. Please come to that Nagpur judgment for a moment, my lord. Para 30. My lord, 1973 1 SCC 500. Please record that submission, my lord. It will have implications because the statement by law officer of the state is very important.
That act is not expressly repealed.
Which, my lord?
64.
But no.
Expressly.
Sir, what is the meaning of then Article 254? I'm not saying expressly. I'm using the word impliedly. I'm not using the word expressly. Express repeal, there will be a repeal. And let us read the repealing act of the 2013 Act, my lord.
And the 1894 Act is.
No. Please come to that repealing provision, my lord.
Yes, Land Acquisition Act 1894 is hereby repealed.
Repealing provision to
114.
Yes, madam. The land save as otherwise provided repeal under shall be held preventive so and so so and so. No, my lord. Here, section 114 deals with express repeal. We are talking of a situation of an implied repeal. Now, my lord, kindly see, 64 Act they have invoked to acquire the land. Forget about, my lord, compensation part. Now, they say for acquiring they will use 64 Act and for compensation they will apply 13 Act. Is it conceivable, my lord? Can state have option of adopting two acts, one of the two acts? So I think I'll have to place the other judgment, my lord, when it becomes repugnant, impliedly.
But that has been an accepted situation. We have submitted this in the state of Arunachal Pradesh where the, along with the 45 Act, the compensation under 2013 has been accepted.
No, my lord, it is not, in my humble view, my lord, the submission, it will not. If a lordship would kindly have,
Same thing exists also in the state of Mizoram.
uh,
Same thing.
no,
The amendment, what do you call the
my
savings of
lordship,
the higher
no,
compensation.
no, my lord, can in the process of acquisition, my lord, two acts be applied?
That is,
And
that
the
is-
preambles are different. I mean, the purpose. One is for urgent and one is for urbanization.
No, my lord.
All those.
64 Act, section 3, reading of section 3 makes it explicitly clear that for some urgent purposes it can be invoked. As I have already given the example, my lord. Supposing there is a flood, a school is to be requisitioned because there is a requirement of rehabilitating the flood affected people. There is a war, etc. There is some natural calamity. It is, my lord, when you want to, my lord, that's why it is said, my lord, the judgment which I have read of the Calcutta Municipal Corporation, where Supreme Court has taken note of the concept of eminent domain. Government is the eminent domain, government is the owner. We are only lessee of the land, even the land where I stay. It doesn't belong to me, it belongs to the state. I have given a lease to live for 30 years. Now, question is, my lord, when you take that right away, Article 300A says it must be by authority of law. Now, authority of law also includes a repeal law. Does it include a repeal law? Impliedly repeal? No. If it is no, then kindly see, here in this case, we do not have anything to say. They will one fine morning, they will issue a notification. My land will vest in the government. Where is the compensation? Now, one thing will kindly see, if a lordship should, why the interim order was passed, yes, last occasion. If a lordship should kindly have that order. Please come to para 9, page 150. Why your lordships passed the order? Thus, from the submission made at the bar, it is not in dispute that land acquisition compensation has not been disbursed to the petitioner. Therefore, the condition precedent for taking possession of the land has.
You are reading which paragraph?
Page 150 below, paragraph 9 of your lordship's order. Thus, from the submission made at the bar, it is not in dispute that land acquisition compensation has not been disbursed to the petitioner. Therefore, condition precedent for taking possession of the land has not been complied with. So, my lord, therefore, next paragraph, my lord, accordingly, as the rule has been made returnable at a very short date, as an interim measure it is provided that the petitioner shall not be dispossessed from the land in question till the next date of listing. So thereafter, my lord, it was extended. So, my lord, that's why I'm saying, my lord, can we countenance a situation where acquisition will be under the State Act and compensation will be under the Central Act? And then what meaning we give to law of repugnancy, my lord? Then Assam Act is not repugnant. And the presidential accent is of what? What by the presidential accent, a new act has not been made. What they done in, my lord, they made a state amendment of the Central Act. That too for what? To bring in section 105A. Why? Because in Schedule 5 they have to insist it so that 13 Act does not directly apply. Now kindly see the act, my lord. Yes. My lord, since it is a motion matter, I will not be very long, my lord. Let me sum up my argument, my lord. My first submission is Assam Act of 64 stood impliedly repealed with effect from 1/1/2014. Why I'm saying by virtue of Article 254(1), Miller, first point. Why I'm saying so, Miller? Because the State Act does not provide any procedural safeguard. It gives drastic power to the Deputy Commissioner or to the state government, any land for public purpose. But for the same public purpose, under the 13 Act, series of procedure is prescribed. So that is being denied when 64 Act is invoked. So, my lord, the submission of the learned Advocate General that for the purpose of acquisition we are invoking 64 Act and for determining compensation we are invoking 2013 Act is itself good enough ground to allow this petition today. But anyway, my lord, I will not go to that extent. That shows, my lord, ignorance about the legal position. The reason is very simple, my lord. If there are two acts available, at your volition you can adopt either of one to cause prejudice to people like us, which you have done. Therefore, it is violative of Article 14 also. Yes.
We
Yes.
are accepting it in two states at least.
Yes.
One is in Mizoram, one is in Arunachal. We have
Yes.
been accepting that proposition.
Yes. Then second, then we lot. Now, regarding now by amending the State Act, sorry, they have carried out an amendment in 24. It received the assent of the President in 25. What was amended? That was a state amendment of the Central Act, that is 2013 Act. It is not an amendment of the 64 Act. Let us be very clear about it. Therefore, the issue is whether by a state amendment of a Central Act, an already impliedly repealed Assam Act can be revived. My humble understanding, subject to what your lordship may say, is no. Therefore, my lord, and most importantly, my lord, I have to part with my property without following the due process of law. That means I have not been paid compensation as yet. A far cry, my lord. Whether in a situation, what is the urgency for requisition of this? My lord, a big lecture has been given, my lord, that Assam will attain 47, will good at first, solve the waterlogging problem of the Gauhati city. No, my lord, I am also a citizen. I have equal right to say.
But you are crossing a limit.
Yes, yes.
You see, when a submission is made by a counsel before the court or
Yes.
senior counsel before the
No,
court,
my lord,
you can't
no,
come
no,
with a
lot of,
lecture.
no, no, what I am saying is, my lord,
take
you,
offense
no,
of
no,
it.
no, lot will kindly see.
See, we are making
Statement was
submission.
made about, no, whenever we say something, we do not say what we mean the other side. Necessarily we speak for our client, he is also speaking for his client. But when he said that we are not, no, he said, he's questioning my bona fide. What is the scope, my lord? We all say that we are all landholders, we have given examples of 5. Whenever there is a requirement, we will come up with that. No, my lord, there is a limit. As a state, you cannot always behave like that. You cannot say no to everything.
Mr.
It's not,
Chaudhary,
it's very correct.
Mr. Chaudhary, you see, for that you don't have to give sermons. Who will speak, which what is, you can't then
No.
make that. Otherwise, the bar will come up with a procedural aspect
That
that
is
in
okay.
court. This is
No, no,
how
I am
it
saying
takes
only
another.
in the context of that statement, that these people are not bona fide. So what is the method to say that our claim is not bona fide? And assuming the Lord, supposing there are situations, I have purchased a land. My name is not mutated. I am the holder of a registered deed. Then also my name may not figure in the Jamabandi. That does not mean I am not a landowner.
That we have already
Yes,
accepted.
yes. So, my lord, in the ultimate, and secondly, most importantly, in the earlier round of litigation, also the same point was argued. And taking note of everything, this order was passed. And as I have pointed from paragraph number Paragraph number, my lord, 9 and 10 of your lordship's order at page 150. The interim order was given primarily on the ground that the compensation has not been paid. So that I'll pray for a similar order, my lord. I understand the other matter on which we are relying is a ditto same, my lord. There is not an iota of difference that is fixed on 23rd. And that statement we have given in our, my lord,
Page
48.
Page
48.
23/7.
23/7, my lord, page 48, my lord.
Take note of it, we'll pass order.
Yes. Page 48, my lord.
No, that's okay, your statement itself is good enough.
Yes, it is fixed on 23/7. So therefore, my humble submission, my lord, going by the principles of, my lord, it should be by, parity. Oh, bless me.
One clarification, my lord, Justice Jahan was saying regarding the purpose of acquiring that land. Lordship will kindly come to page 86. This is just a clarification, Lordship. In exercise of the power conferred to me under section 3, subsection 1 of the Assam Act of 2019-64, notification dated 15 July 1993, I, Swapnil Paul, so and so, do hereby requisition under section 3(1) of the Assam Land Acquisition Act 1964, the land described in the schedule below with the effect from the date of this order for the purpose of acquisition of land for aerotropolis. Lordship will kindly mark this word. Now, this aerotropolis, how it is relevant to 1964 Act. Now, Lordship will kindly come to the 64 Act. Power to requisition, section 3, subsection 1. If in the opinion of the state government, Lordship. Have got, Lordship got it?
You're reading where?
Section 3, power to requisition. Subsection 1, if in the opinion of the state government or any persons authorized on his behalf by the state government, it is necessary to do so for maintaining supplies and services of essential to the life of the community or for providing proper facilities for accommodation, transportation, communication. I am stopping here. So the state is necessary for maintaining supplies and services essential to the life of community or for providing proper facilities for accommodation, transportation, and communication. Now, Lordship will kindly see the meaning of aerotropolis. Not very properly printed. I got a printout from here only. I have a copy. What is the meaning of aerotropolis? Lordship will find little difficulty in reading it, not very legible. May I read it, Lordship? Aerotropolis / aeropolis, airport-centered city. The most common modern meaning of an airport-centered urban region, whereby the airport acts as the economic and transportation hub for surrounding business districts, logistics centers, hotels, offices, and residential areas. The concept is often called aerotropolis and was popularized by urban planning researcher John F. Caserta. Now, these are the photographs of some of the aeropolis. Key characteristics: airport as the primary growth engine, high-speed connectivity for global business, logistics, e-commerce and cargo hubs, hotels, convention centers and commercial districts, transit-oriented development around airport corridors. Notable examples are Incheon Airport and the nearby Sangdo International Business District, Amsterdam Schiphol Airport, the Juidas Business District, Dubai, whose growth is closely tied with aviation center. So various examples are given there. So this is the purpose. So transportation and giving an economic hub for accommodation, various other aspects. So we have to grow. The state of Assam have to grow from the past to the future. So this is a futuristic project and which has the element of transportation and accommodation, which is permissible under section 3, subsection 1.
But those requirements of competition and all those, they will have to take that concept of existing tenants, right? So here, transportation, these airport facilities and the.
The Lordship, so far as it is there for last 40 years, it is like that. But we are thinking about a futuristic growth with industrialization. Why Aeropolis, Aerocity has been developed in Delhi near P3? Because the surrounding areas are all industrial areas. Therefore, all the convention centers, all the logistical hubs, accommodation, plus the cargo hubs also are stationed there. So there is a necessity. It is not that out of the blue this concept has arisen. This is a concept of all modern growing cities and economies.
Lord, we for a moment, we are not against any development. Let us be very clear about it. Question is, we are questioning the decision-making process. You come up with a notice under Section 2013 Act, then we'll have a right of defense. Then we'll say why this required not. Eventually, authorities will take a call. But you cannot adopt a procedure which is not authorized by law to first acquire a land under a repeal act, then pay compensation under 2013 Act. That is our simple case.
And Section 3, subsection 3 permits them to file an appeal before the government. That option is also there. Deeply obliged.
We'll pass authorization.
Deeply obliged.
Sir. Oh, I'm sorry, sir. No. Give me a slip of names.
Judgments.
No.
Appearance.
Appearance names, please.
I'm being item 3.
Item number 3, my lord. The person has been facilitated to file the application. That has been filed. Yes. So probably within 2-3 days, the exit permit will be coming out. That has been informed to my learned friends. Yes. In the meantime, probably.
Mr. D.K. Gawar, counsel for the petitioner. Also had the Sharma and DGC. Correspondent numbers 1 and 2, and RB for 1 and technical for the committee for correspondent 3. Also had Mr. J. Bank as a technical for the border and key border matters. Pursuant to order dated 23/6/2026. The learned counsel for the learned standing counsel for the FT and border matters has submitted that as per instructions received by him, the state has provided due facilities to the petitioner for making an application
For exit permit.
for exit permit. And the application has already been made. So accordingly, it is submitted, perhaps in a few days' time, appropriate exit permit will be issued. In view of the said submissions, the court is inclined to provide that the pendency of this petition shall not be a bar for the concerned authorities, including the Ministry of, this will be Ministry of External Affairs, Ministry of External Affairs, and the Ministry of Home Affairs, Government of India, and the Home and Political within bracket B Department, Government of Assam, to do the needful for facilitating exit of the petitioner to have country of origin. Next. This is the matter on 15, make it 13/7/2026. Next, liberty is granted to the petitioner to make a mention for after term listing, if so advised, before the make an application, before the registry for after term hearing, after term listing, if so advised.
Item number 28 is 28.
Send the record.
In this case, madam, I think the Department of Government of Assam has written to the
Please,
we have written to the External Affairs Ministry, madam. External Affairs instruction is there, madam. External, they are asking, External Affairs Ministry has sent that matter to the madam. They are one of the consular. Then they have said to me that they need the passport document. That details may be provided, madam, to the
What has happened is that
for video interview, then
yes, then only
passport document is available. Last page, kindly second paragraph. High Commissioner wishes to inform the esteemed ministry that the passport database is required for accepting the third SLT. Otherwise, video conference. If they provide the passport documents to the Matia Holdings and officials.
so you see, what happens if that passport data is not available?
In that case,
The petitioner has been taken into custody, serve a sentence. Assuming it is not there. So the, what you call the counselor for the.
provided video interview. Then
This is again Tanzania,
This is Nigeria.
Nigeria.
there is
They will have to get the data from their own.
the next provision is there, madam. The High Commission wishes to inform the ministry that the passport database is required to ascertain her nationality. However, in the absence of passport database, a valid contact details can be provided for the video interview with above mentioned individual to ascertain her nationality. This was last time one problem arose, same problem arose, madam. We have to give a number to him. Yes, that issue was there.
No, but that has to be given once.
Yes, yes. So this
Is the passport.
passport.
In this case. Passport of the.
You provided the,
Here is my learned friend has given this document, my lord, where he has said that he has already the verification is done. My lord, we don't know because we don't have the instruction. If it is already done, let it come through, my lord, Roman, then definitely.
no, that's what we are saying.
Yes.
Just pass it on.
I come to give verification to people.
Mr. D.K. Agarwal, and counsel for the petitioner. Mr. K.K. Parashar, and CGC, correspondent numbers 1 and 2. This R.B. Varar, and government advocate, correspondent number 3, as well as Mr. Vijay Pai, and as planning counsel for the water and FT matters. Next. The learned CGC has submitted that pursuant to the orders passed earlier. He is in receipt of the email dated 25/6/2026 from the Undersecretary from Central and West Africa Division, Ministry of External Affairs from New Delhi. So it would be appropriate to quote this at communication hearing below. Next paragraph. This is the one, huh? Serial number 1. Next paragraph. In this regard, the learned counsel for the petitioner has submitted that in the meantime, emergency certificate has been issued by the Federal Republic of Nigeria which is an emergency travel certificate to facilitate the exit of the petitioner from India within a 90-day window from 9th June 2026. Next paragraph. Therefore, comma, the. Sir, what was there in the last order? How did you say to transport the person? No, not that. How the travel would be made from Assam to the New Delhi to. No, but who will, you will bear the cost of your travel? Okay. So in view of above, year before required emergency certificate dated 9/6/2026, comma, the court is inclined to direct the Ministry of Home Affairs, comma, Government of India, comma, Ministry of External Affairs, comma, Government of India, and the Home and Political within bracket B, bracket code department to facilitate the transportation of the petitioner to New Delhi to the embassy of, this will be embassy or to the High Commission of Federal Republic of Nigeria at the cost of the petitioner, just to allow the petitioner to exit from the country to her country of origin. In this regard, if any support for communication is required, she is presently where? The superintendent from Atia, the transit camp Atia Golpa provides such facility. Including video conferencing with the embassy authorities. Next paragraph. Petitioner shall cause production of a certified copy of the order before the. Instead of that, we say that you can transmit it, the download copy. So accordingly, the learned CGC, state and the learned department council are directed to send a download copy of this order to the concerned authorities to bring the order to the notice of the said authority. Next paragraph, list of 13/7/2026. Next paragraph, if it is granted to the non-counsel for the petitioner to move the registry for after turn hearing, it should.
Supplementary item 30 for motion.
Page number 126. You are giving the but Ms. D. Das, learned counsel for the petitioner, and so for the respondents. Page 126 is the opinion dated 29/5/2026, passed by so and so in case of so and so. declaring the petition to be a foreigner of both consent in 1971. Notice is given 4 weeks, extra copies in the course of the day. Also the records. Here for bail is opposed by the journalist and also for the border matters. Bail of rupees 5,000. 10 days time to take bail of rupees 5,000 to the satisfaction of senior superintendent of police, border, Bongaigaon. To make it superintendent of police, not senior. List after 4 weeks.
Thirty-one.
Yes.
Lordship, the present petitioner is filing his petition seeking enforcement of a direction issued by the Honorable Supreme Court in WPC 1045/2018. Lordship, please come to page number 55. The relevant paragraph is page number 36, Your Lordships. Insofar as the release of the detainees who have served long period of detention in the detention center awaiting their deportation is concerned, we are of the view that the detainees who have been completed more than 3 years may be released subject to the following conditions. Your Lordships, the present petitioner has been under detention since 11/11/2020 to 12/11/2022 for 2 years. Again, he got released on 22/11/2022. Again, he re-detained on 27th May of 2025 and till date he is in detention center. He has been in detention center for more than 3 years, and in spite of clear direction of the Supreme Court for releasing of the declared foreigners from detention center, the present petitioner made a representation before the ST border to Soraido, and he placed them as Your Lordship, the representation is under Annexure 10, page number 70. After making this representation also, they categorically denied to release the detainee. Your Lordship,
Notice you respond to it. We
Lordship,
issue a notice, you respond to it.
Lordship, he has earlier approached this court. Ex parte order was there, this court upheld the order. After
Not
that,
only 35 citizens, please don't interrupt. Do you only have a right to speak? Then, when the other side is speaking, why do you disturb her? This is not the practice which followed here. Did she interrupt when you were speaking? We asked a question to her. She has a right to respond.
there's already an ex parte order which this court has upheld,
No,
Lordship.
not that. Page 35 is the Supreme Court order on which is banking.
35 is that so motu order, Lordship, during COVID, that order was
No,
passed.
no. This is after that, 2020, the next order
In the Lordship,
is after that.
35, Lordship is referring to page 35,
No, 33. First is
33,
33. The review petition was dismissed
yes,
on
Lordship.
10/3/2026. Now the order is of 10/5/2019, page 35, which says that the release of the detainees
35 is a order of Lordship. Lordship, this order is of 10/5/2019.
okay,
At page 35, Lordship.
35, yes.
35, Lordship will see just below Union of India, date is written. This order is not a recent order. This is a very old order, Lordship.
On the subsequent order, page 38, this is 2020 order.
Page 38 is 20 order. This was passed during the COVID time, Lordship. This was a blanket order passed. Lordship, this review was filed recently, only the ex parte order which was dismissed by this court also. Then they approached the Supreme Court in 26. This order, which is at page 33, is of the review order, and review has also been dismissed. So her being in the detention is legally it is not incorrect. She has been picked up and placed in the detention because the ex parte order was upheld by this court, and she has approached the Supreme Court only in 25 after the 2019 order. So when she was in detention for the first period, she was released because of COVID. Those who have completed 2 or 3 years, they were released. And now subsequently, because that ex parte order still has been upheld, so she has been again detained. She's a declared foreigner, and she has, in all her proceedings, the court has upheld the order of the tribunal and the High Court, and the review has been dismissed. So there is nothing wrong with her detention, Lordship.
Lordship, I'll understand whatever submission made about citizenship, your Lordship. Yes, we admitted that after the FT order, we approached the honorable this court. This court also passed an ex parte decree, we went to Supreme Court for review. That also got dismissed. Again, we go for revision, SLP then review, it all got dismissed. Your Lordship, case number 36, the lecture 5, the judgment which we are talking about, it is for the release of claim, because detention is not a punishment. They are awaiting deportation, your Lordship. So in this judgment, it is categorically mentioned that insofar as the retaining has been concerned. Your Lordship, the learned friend says about the suo moto. Yes, there is suo moto case in between this, where the Supreme Court relaxed the security amount to 5,000. But your Lordship, case number 32 to case number 52 to 69, annexure 8 to 9, your Lordship. Again, the Supreme Court recalled this suo moto order because the situation is not prevailing, COVID situation. Once they recall this order, the order of 10/5/2019 still hold virtually. Because it about the deportation, you know. We recall the order of COVID-19, the suo moto 01 of 2020.
So if the order is recalled, she is still a declared foreigner.
She is a declared foreigner.
What is the parametric provision of section 4 of the Foreigners Act here under the new act?
Lordship, I do not have a copy of the new. Lordship, at page 59, the last order of the Supreme Court, which my friend said has recalled, Supreme Court did not recall, Lordship. It says that all those convicts and prisoners who were released ought to surrender within 15 days. That is at page 59 and page 60. Go to next one. Foreigners Act 82. Foreigners Act.
We're issuing notice. The reason is that you see under the Foreigners Act,
Yes, Lordship.
section 4 has the provisions for internees.
Yes, Lordship.
There must be some provision under the new act under which you have, you can keep a person at the designated place. You have to
She's
get those
already in the
notification or something.
detention center, Lordship. She's already in the detention center.
But you see that the issue will arise because this after the new act of Immigration and Foreigners Act,
Yes, Lordship.
the Foreigners Act got repealed. So there must be some provision to continue the detention under to a declared foreigner. What is that provision?
Lordship, first we have to make sure she is still there. She must have been pushed back because,
No, that's a second point.
yes,
The issue is how do we deal with the internees? The
Yes,
transit camps
Lordship.
were open for the purpose of section 4 of the Foreigners Act. Now what happens with the repeal?
We'll have to get instructions on this.
That's why.
Yes, Lordship. And whether she's still there or not, even on that part,
Get
Lordship,
that
because
instruction.
she was detained. She's still
Get that
there
instruction.
in Gauhati. Bhatia. Bhatia.
Your name?
Is Horia.
And Mr. A. Sahariya and counsel for the petitioner
Nothing like that, no?
and so for the respondents. The petitioner is a declared foreign national pursuant to the opinion dated 4/12/2018, page 19, passed by so and so and so and so, which has attained finality after dismissal of the writ petition to assail the said opinion and dismissal of the
Faculty and review, Lordship.
SLP civil diary numbers 60991/2025. By order dated 7/11/2025, page 28. And dismissal of the review petition referred thereafter. Being order dated 10/3/2026, passed in review petition within bracket C. Then D number 75430/2025, page 31. Next paragraph. The petitioner is now praying for bail in terms of order dated 10/5/2019, passed by the Supreme Court of India in WPC number 1045 of 2018, page 35. Next. Issue notice returnable on 17/7/2026. Extra copies of the petition with all enclosures be provided to the Lanet CGC State and Department of Counsel in course of the day. Next, list transfers. Yes.
For motion, supply item 32.
Which position did you give us?
The impute order is at page 62. Page 62. Also, very interesting to find in the last page of the impute order, page 70, where the tribunal has failed to mention under which stream he has declared the petition as a foreigner. Whereas the notice also is not clear, not identified, whether it is alleged between 71 or 47.
Lordship may issue notice because this point can be taken up during hearing also, Lordship.
We have already decided that issue.
Yes, Lordship.
In a lot of cases, we have decided that issue. Mr. S. Ahmed, learned counsel for the petitioner and so and so for the respondents. Page 61, opinion dated 6/12/2019, passed by so and so in so and so, declaring the petitioner to be a foreigner post 20th in 1971. Challenge is made on the ground that in the notice as well as in the impugn opinion, the petitioner was not declared. The stream under which the petitioner had entered into the country has not been declared. And in this regard, the understanding also for the FT and border matters is submitted that the issue is quite settled by the law laid down by this court. Next, in view of the inordinate delay in asserting the impugn opinion, keeping the issue of maintainability open, issue notice returnable on due date on so and so. Extra copies in course of the day, copy of the records. The prayer for bail shall be considered on the receipt of the tribunal's records. In the meantime, if the petitioner MD so and so is apprehended, she shall not be deported out of the country without order of the court. Next, the petitioner shall cause production of a certified copy of the order before the Superintendent of Police border. Which place? Nagaon, to bring the order to the notice of the said authority. This councils.
14th of August. For delivery order, production list item 1, WBC 5393/19.
The writ petition is dismissed. Case to be
I have a small prayer, Lordship. Item 14 and 15, Lordship. It may be, a date may be fixed.
14 and 15.
Yes, Lordship, I am the petitioner.
No, Mr. Chaudhary is sitting for quite some time.
So my item will not reach, my lord, I was just sitting, because my lord, I was taught, my lord, we should not leave the court when the court is about to rise, that is respectful.
No, that's true. That's how we were groomed up. Thank you for following that. But we don't want the senior counsels to also do it. You can leave.
Okay.
You have certain liberties.
All right.
Item 14, 15.
14 and 15, I should be this side now, Lordship. So, Lordship,
14 and 15, it's a PIL.
yes, Lordship.
Okay. There's no prohibition for that. Changing sides. Okay, give a date, 14, 15.
After 18th of July, Lordship.
Mm. 23rd of June.
For other matters, Mr. Chaudhary, Mr. Das, everybody is waiting. we are not be able to take up.
Will the bench not be sitting at 2 p.m. again? I have not seen them.
At times we also have to take some liberties.
My lord, yes. I know it. Then all we can do from our side is wish Lordship a happy vacation, my lord.
Thank you for your wishes, but we may not have a good vacation. There are a lot of CAVs
No, no,
to
my
be
lord.
dealt with.
Expectations is everything has to be good, my lord.
There are a lot of CAVs to be dealt with. There with many administrative files have come.
My lord.
We have at least, I have at least 40 files, official files to be dealt with. Then you have to, what do you call, a lot of administrative work has to be done. So, but thank you for your wishes.
My lord.
Mr. Mazumdar was here, Additional Advocate General.
Dilip Mujumdar, he has just left now. He left, my lord.
Okay, thank you.